Every single day, you leave a digital footprint whether you realize it or not. Your smartwatch tracks your morning run. Your Alexa speaker hears your kitchen conversations. Your phone logs your late-night searches, and your doorbell video camera watches neighbors passing by on the sidewalk. But who owns that data, and who gets to see it? To find the answer, we have to look backward, to what life was like before we had privacy rights at all. Before the American Revolution, British officials used powerful, open-ended documents called writs of assistance. These were essentially blank check search warrants. On suspicion alone, an officer could ransack any home, business, or ship looking for anything deemed illegal. It was a massive, unchecked dragnet, often abused for personal revenge.
I'm going to search your house and I don't need a warrant or probable cause.
By 1761, the colonists had enough. 63 Boston merchants hired a brilliant lawyer named James Otis to fight these writs. In a fiery, historic speech, Otis took a stand.
Now, one of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. This writ, if it should be declared legal, would totally annihilate this privilege.
While Otis technically lost the case, his words were the spark needed to fight against these egregious overreaches. 3 decades later, that spark became law. The Fourth Amendment was ratified, explicitly protecting citizens against unreasonable searches and seizures. Now, the government needed a reason, a judge's signature, and a physical warrant. For over 2 centuries, the Fourth Amendment stood as our most vital shield for personal privacy. But what does that shield look like in today's digital world? The Fourth Amendment was written to protect physical things inside a home. But today, our lives are stored on cloud servers owned by multi-billion-dollar tech companies. In the 18th century, the British government used the writs of assistance to unlawfully search homes and businesses. Today, government agencies can simply buy your location data, your search history, and your daily habits directly from private data brokers. The dragnet didn't disappear, it just went digital. James Otis fought for the idea that a person's home is their castle, secure from unchecked government eyes. Today, our castles are digital, and the lines of defense are being redrawn right now. The Supreme Court has faced hundreds of Fourth Amendment battles over the years, scrambling to adapt old laws to modern realities like wiretapping, GPS tracking, and smartphone data. But the digital legal battle is far from over. Can an 18th century document protect the data on a 21st century smartphone? To understand how the core principles of our founders apply to a world of gigabytes and algorithms, we turn to Dan Schmidt, Professor of Information Technology and Cybersecurity at Austin Community College.
No, a great question when we think about the Fourth Amendment and what it does today with regards to the information. It's meant to protect us. When we think about our phone is our desk drawer that the founders were worried about. Except now our phones are also our maps, our diaries, our social life, our medical files. The principle around the Fourth Amendment hasn't changed. Government shouldn't go casually and assemble this intimate portrait of our lives. What's changed is the scale. Surveillance used to be incredibly expensive and targeted, but now it's cheap and automatic. And that's one of the things that's really scary. The Supreme Court has tackled this a little bit, but the last time they really tackled it was 2018 in Carpenter versus the United States. And that's where they said, we can't use cell site location data, like when your phone checks into cell phone towers. That information needs a warrant because it reveals an intimate window into someone's life, but there's still a very long way to go. And that case was 8 years ago. There's still opportunities where cell phones and these digital drawers that the founders were so concerned about, they're still being exploited and used unfairly in violation of the Fourth Amendment. It just hasn't gone to court yet.
What principles were the framers trying to protect with the Fourth Amendment, and how relevant are those principles today?
So if you strip away the muskets and the powdered wigs, it's about 2 things. Government needs a reason, and a neutral party has to check that reason first, and that neutral party is a judge. They weren't protecting diaries because diaries were sacred. They were protecting the idea that government can't rummage through your life on a hunch. But today, your life is gigabytes of data, location pings instead of paper. It's the same principle, it's just in a different container.
How is modern digital surveillance testing the limits of the Fourth Amendment?
So there's this old rule, the third party doctrine, it came around in the 70s. Once you hand your info to a bank or a phone company, in the 70s, it was determined that you've given up your privacy to it. And that was fine, except now everything we do involves a third party. So when we think about, what kind of problems there are when the government buys or acquires privately collected data, and we look at the Fourth Amendment, that restrains government searches. It says nothing about data brokers selling your location on the open market. So an agency that needs a warrant to get your location from your phone carrier can also just buy the same data with no warrant, no judge. The Department of Homeland Security's own oversight office flagged this as an issue. ICE bought commercial location data for immigration enforcement, even after agency lawyers warned it was likely unconstitutional. It's a law against breaking into your house that ignores the guy on the corner selling copies of your keys, is really kind of what it amounts to.
Explain to me who is selling our open data. Who's buying
So
it? Who's selling it?
everybody and everybody. Data is a $1 trillion a year industry. And when we think about how our phones, especially our phones, when we have the feeling that our phones are listening to us and watching us, we're not wrong. You can walk into a bookstore, and if your phone checks in with the Wi-Fi, it knows how long you stood in the gardening section of the bookstore based on the access points in your position within the bookstore. So when you go home to a website and you see an ad for that book you were staring at, someone has bought that data and is already using it to try to target you. Additionally, there are options on the internet now where you can go to these data brokers and ask for your data to be removed. Usually you have to go to several different ones. It's pretty low friction at this point where you just go in there and say, hey, I don't want my data being tracked. Any data you have on me, I need you to remove it from your database. That's an option as well. But it's one very few people are aware of because of just how valuable data is these days.
What safeguards, oversights, and transparency should exist around AI-assisted surveillance and facial recognition technologies?
So this is obviously something that's changing pretty frequently. When warrants have requirements, they should be tied to specific investigations, not just this kind of standing access to get information about crowds that are out there.
I'm Cindy Wallingford, and Delete Me has been very beneficial in getting my information off the internet. Log in to deleteme.com for more information.